273 down to 996 at 1996. But there are other land blocks that began quite large, for example, Waifatafata at 2109, going all the way down to 243 acres. So this shows that the hapu suffered extensive land loss within their rohi. In terms of all of these land transactions that I'll be speaking about, in general, the hapu always wanted to be receptive and open in terms of exercising rangatiratanga over their lands by having a reciprocal relationship with the Pākehā settlers that had come in, and by doing so as an assertion of their mana, they often engaged in there were instances where lands were given to these Pākehā settlers to be able to establish the communities and create utilities that could help their communities thrive. Okay. If we go to paragraph 87 there, the Crown has conceded, moving to the Crown concessions, that there are breaches regarding the 10 owner rule, that the individualisation and fragmentation of the land has undermined traditional hapu structures, but the Native Land Court as an institution did not breach the treaty. However, there is much evidence that shows the contrary to this. If you go to paragraph 131, I'd like to highlight that there is a Pākehā Kokohuia report that was undertaken for the purpose of this inquiry. And in that report, the claimants did intend on contributing to this. However, a number of the instances that we requested be looked into did not. So this makes a full assessment to the extent of the breaches for these blocks quite a difficult exercise for the claimants. However, it is clear that, for example, in that Pākehā block example, how it went from 13,000 or so acres down to 1,420, it shows the extent of land loss there.
Sorry, can you one step, because you said, and I know that the Crown has made a concession regarding the native workings of the Native Land Court, but noting that the Native Land Court itself is not a breach of the treaty. But you say it is, and you say, and there's a lot of evidence there to show why the Native Land Court is itself a breach of the treaty. Just summarise, what are those reasons?
In summary, the functions that the court was allowed to exercise enabled alienation of land from the claimant's tupuna. I will be talking to you about examples where succession has been a big issue for the claimants, in that people weren't consulted with, they weren't able to show up to hearings when they were at the hearings and were protesting,
so what the court did,
what the court did in that respect.
The legislation, I presume, that you're going to say that that's in breach, the policies of the court, but that's right. The court at set?
It is my understanding that the decisions that were made were in favour of certain groups over others, and so that's how they have had some of the land blocks were lost from their possession. Could I submit further on?
I mean, the Native Land Court has been an issue discussed in a number of tribunal reports. Is there any tribunal which has found that the Native Land Court itself has been a breach of the treaty?
Would I be able to submit that in writing?
Yes.
As has been highlighted in the Hokianga opening submission, there were a number of perceptions of the Hokianga in terms of their relationship with the Pākehā that could be construed in a way that mean that the land block, that the intention of the tūpuna there was to sell the land however, Council submits that in a number of cases, the definition of the sale is of a contention because, and for example here, page 36, 142, in the sale of Pākenai 1, it had been construed that sale of Hapakuku Moeatara to the Crown was a sale that was a lease, not a sale. So this is a tuku rather than a hoko. We questioned Ms. Clarkson about this issue. She said that she has found no strict evidence in the records stating that it was a sale, and there were a number of motivations that may have been in play. Council submits that the claimant's tūpuna did not intend to sell the lands, and there is a lack of detail regarding this, regarding store debt sales to support this proposition, and that there had been no need to permanently sell the land. Now moving to paragraph 175, I'd like to discuss gifting of lands. So Kokohuia B1, B2, there was a plan there to build a meeting place. The tūpuna had wanted a church to be built there for a while, and they had been practicing, so they intended on building a marae, so they, building a marae as well. And in 1962, that came before the court. B1 was set aside as a reservation, and B1, B2 was partitioned church there. One issue there is that the court had made a mistake in terms of the actual gazetting of the land, so the family had to go back and get it re-gazetted to recorrect the errors of the court. They also incorrectly surveyed the land there, so they had to go back and get that resurveyed. There was also issues in terms of the succession, because the lands were succeeded to somebody who didn't whakapapa to that land. So basically, the lands were vested in the General Trust Board of the Diocese of Auckland. However, the church was never built. There was never a church that was built on that land. Merigana Watene, one of the witnesses, has stated that our tūpuna intention was to have that block set aside as a reservation for the benefit of the Māori people of Northland for the church. But instead, today, the B1, B2 block is held in the General Trust Board. The land is no longer in Māori ownership, with pensioners paying rent to live in the flats, a few derelict kauri buildings there, and a vicarage which is rented out to the public, not used by the church. Another example of gifting of lands, 241, going to paragraph 146 there. So here we had Iohu Moeatara, who applied for confirmation of the transfer of that land block in 1920. The land was confirmed for an alienation. And then in 1921, Iohu wrote to the president of the Tokoro Māori Land Board stating that in consideration of the board agreeing to confirm the sale, he undertakes that it be vested in the Diocesan Trust Board again. The land was vested in the board. The land was then gifted, but then Iohu went and wrote off that the $50 effectively the consideration that they were going to be paying him. So he obviously gifted the lands because there was no transfer of money in that transaction there. So council submits that in this situation, because it is a gifting of land, when the church site is no longer used as a church anymore, because there is a church there to this day, the church site should be returned to the descendants of Ehu Moetara, who had purchased and gifted the land to the Board of Trustees of the church. In terms of gifting of lands, the Crown hasn't put up any evidence to the contrary. Council submits that this gifting of lands of the claimant's tūpuna is an assertion of their rangatiratanga because it's a way that they're showing their kaitiaki-tanga and in establishing the relationships with others in their community to show an assertion of mana. In the way that the Crown allowed these transactions to take place, that is where the good faith obligations of the treaty are breached. They failed to honour the obligations of the treaty, and the Crown owes an obligation to the people to ensure lands are properly protected, and as such, where lands are gifted for this purpose, where it's effectively held there, the Crown has a duty to assist the descendants in the return of their lands. At paragraph 260, the amended statement of claim shows that the hapu have been involved in a number of land development schemes within the southern Hokianga. So I'd like to draw attention to the Kokohuia unit farms, which are described by Miriana Watene and Claire Te Whata. So that is Kokohuia D and Kokohuia E. At paragraph 263 onwards. So the whānau that lived on Kokohuia D had been there for years. They weren't farmers, they weren't fluent in English, they weren't really cognizant of business structures, etc. However, the Crown came in and said, hey, let's find a way to utilise your land in a way that would make it more productive. Bearing in mind that the lands itself were rough, hilly terrain, no access to the road, and really not the best farming material. So the Crown put up this suggestion through this land, the Kokohuia unit farm. The claimants tūpuna were provided with assistance to do so, but of course they had to repay that debt through the Native Department, through deductions of their cheques. They, as stated by Ms. Ross, they were effectively forced to incur debts, and these debts were often incurred at the store because there were no banking institutions in the Hokianga at the time. They had no money because they had to pay off these debts, and the Crown, because the Crown did not have any support there to assist them with that. The profits didn't go back to the farmers, and due to lack of employment, the tūpuna could not pay back the store debt, and in lieu of this, their tūpuna had to sell their lands to pay back store debts, forcing the sales of lands to a number of store owners through private purchase, which of course cannot be returned. The Bassett and Kay report describes the difficulties that they experienced during their time managing these farms. It also speaks about the lack of access to finance through banks and other institutions as being a major obstacle for Māori farmers at paragraph 267. So when you mount all of this up, so no access, no financial institutions, not being able to communicate with Crown officers because of a lack of lack of comprehension, having to pay for utilities, and laying on that the Crown knew that the lands in Hokianga were uneconomic, but they went ahead with the schemes anyway. And they know this because of the Māori Affairs Committee acknowledging during a meeting held on June 1963 that small-scale farming, such as that at Kokohuia, was hopelessly uneconomic. However, as the farms were there, they had debts which had to be recouped, and the people had to continue to farm. However, it was not the department's objective to perpetuate that kind of settlement. The council submits that because the Crown knew about the difficulties of farming and the hardships that the claimants tūpuna have experienced, that is a clear breach of the treaty. There was simply no way that land development schemes in the Hokianga could be economical due to the costs imposed. And these are costs that were imposed by the ministry, such as survey fees, livestock, machinery and other chattels, and the lack of financial assistance available from the Crown. But in effect, the effect on the people was more than just economic, because, for example, as Mr. Gibson of the Māori Affairs Department had said, there are very low prospects for these small land development scheme farms. By parents insisting on bringing their children back onto the farm, they were, in many cases, sentencing their wives and families to a life of poverty. Moving on to Kokohuia E. Clara Te Whata inherited the Kokohuia E farm from her parents who farmed the block. There was already a mortgage on the land because of the reasons I've explained earlier, similar to her cousin there. She asked for assistance, further assistance on this, but was denied. And even though they said that they would help, they did not at all. Here I'm referring to Māori Affairs. I'm at paragraph 277. In terms of financial commitments to the farm, she said that she had to pay for supplies as well, and if they needed anything extra, I had to pay for it. If I ran out of stuff before the end of the month, tough luck. She decided to convert the farm to beef production, but then they denied that. They wouldn't allow her to do that. Council submits that this is one way in which the Crown has attempted to put a cap on their rangatiratanga so they aren't able to exercise kaitiakitanga to its full extent. Further to that, that particular block, as stated by Ms. Shane Dick, was unsuitably hilly, rough terrain, not serviced by a road until it was constructed 23 years after the scheme had begun, and the land was too small to be economical anyway. Another thing that's often missed out in terms of land development schemes is how the Crown did not recognise the hapu connection to the land, as acknowledged by Ms. Dick. So people weren't allowed back on their lands, and they weren't able to go back onto their wāhi tapu sites, especially when the farms were managed by others that weren't part of their hapu.
Ms. Loader, just noting you've got another 5 minutes to go.
So at 284, there are other subsequent effects of being involved in the land development scheme, including unemployment, urban migration, substandard living conditions, and substandard education. So now moving on to page 85. This part of the submissions speaks about lands vested in the Māori Land Board. We have covered that there, so I won't go over that specifically, except to draw attention to paragraph 379, and that's with the sale of the Tai Whati Te Whati block. So if you could pay special attention to that.
So what's the point there in terms of the Māori Trustee and the Māori Land Boards?
Okay. So when lands were vested in the Māori Trustee, it meant that the claimants tūpuna were not able to exercise the rangatiratanga over the lands because they didn't have control over it. The clauses that were imposed were very onerous on them as well, and were often far beyond what was expected of them. For example, it could be leased up to 50 years. That's a whole generation where they had lost the use of their land.
Okay.
Yep. So I'd like to, because I have a short amount of time, I'd like to draw attention in particular to taonga tūturu. This is something that we cross-examined the Minister of Heritage on. So they spoke about...
Ministry?
The Ministry of... who was it? The Chief Executive of the Ministry of Culture and Heritage on. He spoke about the provisions that have been... the provisions under the Protected Objects Act. So under the Protected Objects Act, he acknowledged that that hapu have interest in taonga tūturu, but by the end of it, he said effectively that all of the decisions that are being made by, about taonga tūturu that are found are actually vetted by the ministry anyway. So council submits in short that this means that the hapu cannot exercise kaitiakitanga to its full extent because they're still operating within this Crown system. This is in specific reference to taonga called Piwakawaka, found in the Piwakawaka and Kohikohi caves, and these taonga were taken from the caves by the Crown. They're now sitting in the Auckland Museum, in fact, and they haven't been returned to the hapu. So in terms of concluding remarks in the interests of time, there are a list of findings and recommendations at page 145. However, I'd just like to say that what clients really want is an acknowledgement that their claims are well-founded, and the finding that the facts are in their favour, because from there we can come up with some decent resolutions that would in fact, improve the treaty relationship there. So I'd like to read out at paragraph 592. Throughout the process, the claimants have stated that we need to remember that this fight is truly against the Crown as our partner in Te Tiriti, and it is the failings of the Crown that have created Raruraru here today. There should be hui, kōrero and consultation of open-hearted nature between the hapu and those that recognise and embrace the wairoa of this wāhi tapu, and how to best honour, preserve and pay respect to the whenua ki te moana, ki te rangi, me ki te wairoa o ngā tūpuna. The Crown has a duty of protection, but also has a strong record of not doing so. The claimants want their tino rangatiratanga back over the things that are so special and sacred in the hokianga. It is insulting to have to buy back places that the Crown never paid for and then just on-sold. Through this process of the tribunal, the hapu can learn more than they ever have learnt before, which in itself is a taonga. Our history is being put right through this process, and if we can get it right this time, then it would be a godsend.
Kia ora. Anne, do you have any? Robin? We have no questions on that. Maramana, very clear. Thank you. We now move to
3.3.268A.
268.
Tēnā koutou katoa. Council's name is Miss Leonga, and I appear on behalf of Y779, the claimants for which are Donna Washbrook and Warren Moitara. And they bring this claim for and on behalf of the descendants of Ngā Uri o Yehu Moitara Trust. A copy of the trust order was attached as Appendix A to the Y779 amended statement of claim filed on the 19th of May 2017. Council wishes to emphasise and acknowledge that the focus of the Y779 claim is on the claimant's tūpuna Yehu Moitara and Council acknowledge and pay respect to Yehu Moitara today. Council also acknowledge the claimants and their whānau who are present today, including Donna Washbrook's brother Robert and son Anthony. The amended statement of claim and the amended closing submissions together highlight each of the breaches of Te Tiriti and the subsequent prejudice the claimants and their tūpuna and their whānau continue to experience today. Council adopts the generic submissions in relation to issue 7 and issue 8. Council also rely upon previous tribunal jurisprudence set out at paragraphs 309 to 320 of the closing submissions. The claimants presented evidence during hearing week 20. The purpose of their evidence was to provide a tangata whenua perspective and insight into the true and correct history of the Pākānai school lands. Uncovering the true and correct history of the lands is an important kaupapa for the claimants, as it also uncovers the breaches of Te Tiriti. The claimants provided extensive technical and tangata whenua evidence. The evidence that they've filed is detailed at paragraph 9 of the submissions and includes technical briefs of evidence and appendices as well as supplementary briefs of evidence. The technical evidence filed on the record of inquiry, which concerns the Pākānai school site, include 3 main reports. These are the Northland Gifting of Lands report, the Pākānai and Kokohuia Lands 1870 to 1990 report, and the surveys and land transactions associated with the Pākānai school site. There was also further evidence and numerous questions and answers filed for technical and tangata whenua witnesses, and the details for those are at paragraphs 10 and 11 of the submissions. The Y779 claim answers issues 7I, 8L, 8J and 8M of the Tribunal Statement of Issues. In addressing the question of what is the nature of the claim, the Pākānai school claim is essentially about the provision of land for the Pākānai school and what happened to the land when the school closed down. The Pākānai school claim is founded on the generosity of the claimant's tūpuna. The claimant's tūpuna out of aroha for the Pākānai community and in support of both Māori and European children having access to education, gifted land to be used for the purposes of the Pākānai school. Despite their generosity to provide land for the school, when the school closed down over 45 years ago, the Crown failed to act in good faith and partnership and failed to return the land to the claimants and their tūpuna. Council will touch on some of the key issues which need to be emphasised to the Tribunal. These are issues that need to be corrected and acknowledged in order to rectify and put right some of the past breaches of Te Tiriti that have taken place. The land blocks that were involved and used for the Pākānai school include Pākānai number 2, Pākānai 2Y and Pākānai 2Y3. Our first focus in the submissions is on the first piece of land acquired for the Pākānai school. The amended statement of claim and the claimant's evidence looks in detail at the history of the first and original piece of land that was provided for the Pākānai school. Council submit that...
Whereabouts are you?
So I have moved to paragraph 17.
Okay.
Council submit that neither the Gifting of Lands report nor the Pākānai and Kokohuia report looked into the specific details and history surrounding the first piece of land, who owned it and who provided it for the Pākānai school. So paragraphs 17 through to 35 of the closing submissions discuss in detail how the first piece of land used for the Pākānai school was Pākānai number 2, section 44, although a lack of survey after the 1889 hearing has identified the land as simply being on Pākānai number 2. Council submit that at the time the first piece of land was provided for Pākānai school, the land had been through the 1889 partition hearing and had been allocated to the claimant's tūpuna. Trevor Shaw's report provides the details concerning the surveys and partitions of land that took place in relation to the Pākānai school site. His report confirms that in 1887, Pākānai number 2 was subdivided into 77 separate parcels, although the various parcels were not allocated to any individuals at that time. Trevor Shaw's report confirms that in 1909, the first survey for the Pākānai school was completed. SO Plan 14935 showed that land for school and land for church was located on Pākānai number 2. that the first piece of land provided for the Pākānai School was actually Pākānai number 2, section 44, and was owned by the claimant's tūpuna, was confirmed by Ms. Clarkson in her report and during cross-examination. There is no evidence to confirm that there were any other owners of Pākānai number 2, section 44, between 1889 and 1909, when the first Pākānai School building was completed. Moving to paragraph 41, page 12 of the submissions, Council discusses the issue of whether the settlers purchased the land. Council submit that there is no conclusive evidence to show that Pākānai number 2, section 44 was sold by the claimant's tūpuna. Paragraphs 52 to 59 of the submissions explore the lack of evidence to confirm a sale and purchase took place to the settlers and residents of Pākānai. Moving to paragraph 66 onwards to 77, Council submit that it was the intention of the claimant's tūpuna to gift the land for a school site. The brief of evidence of Donna Washbrook speaks to the generosity of her tūpuna Yehu Moitara and outlines the minutes of the hearings he had been involved in and his express intention to gift land for the Pākānai School. The brief of evidence of Warren Moitara summarises the evidence of the claimant's tūpuna, where he states, and I quote, "The important evidence we wish to highlight is that our tūpuna provided the land for the purpose of a school and church site. This is reiterated by our tūpuna Yehu Moitara in 1936 when he provided a further area of land for the school site and is recorded in Māori Land Court records as saying, 'I gave this school site at Pākānai, and this is another of my acts of aroha for the people, and this is a straight out gift.' Rather than being a sale of land and rather than being a transfer by way of gift recognised by the court, Council submits that the evidence available shows that the first piece of land used for the Pākānai School site was in fact vested in the Tokoro District Māori Land Board. Paragraphs 82 to 97 discuss the vesting of the land in the Tokoro District Māori Land Board. On the 21st of June 1909, an order in council was made vesting land containing 2 acres, 1 perch, more or less being a portion of the block of land known as Pākānai number 2, as shown on plan SO 14935 in the Tokoro District Māori Land Board, under section 24 of the Māori Land Claims Adjustment and Laws Amendment Act 1907. Paragraphs 98 to 104 of the submissions discuss the actions and omissions of the Tokoro District Māori Land Board. Council submits that it is clear that the vesting of the land in the Tokoro District Māori Land Board without consultation and the express consent of the claimant's tūpuna is a breach of te tiriti. Furthermore, the Crown has conceded that the compulsory vesting of land in the Tokoro Māori Land Board between 1907 and 1909 without owner consent breached the Treaty of Waitangi and its principles. Council submit that despite the land being vested in the Tokoro District Māori Land Board for the benefit of the Māori owners never received any benefits from the vesting of their land in the Tokoro District Māori Land Board. Moving to paragraph 110 to 120 of the closing submissions, we see how the land, once it was vested in the Tokoro District Māori Land Board, then was transferred to the Education Board. On the 23rd of March 1910, 1 acre, 2 roods and 1 perch of the Pākānai number 2 block was transferred from the Tokoro District Māori Land Board to the Education Board. Council submit that the Education Board did not purchase the land, but title was formally transferred to the Education Board from the Tokoro District Māori Land Board. Once the Education Board had ownership of the land, they also received all control over the land. The issue of a payment of £7 10 shillings is mentioned throughout paragraphs 110 to 130 and is explored further in the context of whether the claimant's tūpuna received any of the £7 10 shillings in paragraphs 131 through to 148. Council submit that there is no evidence from a tangata whenua perspective to confirm that the claimant's tūpuna did receive £7 10 shillings. If a portion of the £7, 10 shillings was received, there is no evidence to suggest that the claimant's tupuna understood what it was for or that they had agreed to receive it in exchange for the full and final alienation of their land. The Pākānai School was completed in 1909, and the first possible part payment of the £7, 10 shillings for £3 and 15 shillings is recorded in 1922, 13 years after the Pākānai School was built. Council submit that the importance of identifying the correct history in relation to this first piece of land cannot be understated. Council submit that the subsequent dealings with the Pākānai School land which took place were based on misunderstanding that the Crown had legitimately acquired the first piece of land for the Pākānai School. Council wished to highlight that Pākānai number 2, section 44, eventually became absorbed into Pākānai 2Y after Māori Land Court sittings held in August 1922, and the effect of this is that Yehu Moitara, the claimant's tupuna, became the sole owner of the block. At paragraphs 151 to 160, we discuss the subsequent gifting of land, 1 rood and 18 perches of Pākānai 2Y3 by the claimant's tupuna Yehu Moitara for a playground for the Pākānai School. At paragraph 154, reference to the brief of evidence of Donna Washbrook and Yehu Moitara's statement in court in 1936 is provided. 1 rood and 18 perches of Pākānai 2Y3 was formally acquired under the Public Works Act 1928 for the purpose of a public school. No compensation was received for the gifting and the alienation of Pākānai 2Y3. Paragraphs 162 to 180 provide details in relation to land used for a teacher's residence. On the 9th of March 1940, a proclamation was made declaring 2 roods of Part Pākānai number 2 block taken under the Public Works Act 1928 for the purpose of a public school. These 2 roods of the Part Pākānai number 2 block taken for the teacher's residence was part of the area formerly reserved as a church site and was vested in the Tokoro District Māori Land Board in 1909. These 2 roods were then vested in the Education Board on the 9th of March 1940. Again, no compensation was awarded. Council wish to highlight here that the teacher's residence is still in Crown ownership today and has been incorporated into a new survey plan, which is 59695.
5 minutes to go, Ms. Leonga.
Paragraph 184 to 190 discuss the details regarding part of Pākānai 2Y, which was taken under the Public Works Act in 1963. Yehu Moitara, who was an owner of Pākānai 2Y, had passed away in 1942. He was still listed as an owner when the Crown took the land in 1963 for a public school. Compensation of £30 plus interest was paid to the Māori trustee for this taking. However, there is no evidence to confirm that the claimant's tupuna were consulted or received any compensation from the Māori trustee for this taking. Paragraphs 194 to 197 discuss what happened to the Pākānai School when it closed in 1972. After it closed down and was declared surplus to requirements, the Youth Hostel Association took up an informal lease of the Pākānai School. Council submit that the Youth Hostel Association should never have been allowed to use the Pākānai School land without consultation and consent from the claimants and their tupuna, as the use of the school went outside of the use that the lands were gifted for. At paragraphs 201 to 212, we discuss the Public Works Act and offer back procedures. The pieces of land that were formerly acquired under Public Works legislation and declared surplus to requirements included part of Part Pākānai number 2, part of Part Pākānai 2Y, and part of Part Pākānai 2Y3. Part Pākānai number 2, used for a teacher's residence, as we've mentioned, was formerly acquired under Public Works legislation in 1940, although it was originally vested in the Tokoro District Māori Land Board, so it had a different outcome with that specific piece of land. The Public Works Act 1928 was still in place when the school closed down, and the Crown did start to discuss amongst its departments what should happen when the school closed and the lands were surplus. Because the Crown wished to retain part of the land, the Crown made inquiries with the wider community about retaining that land. And this is in Council's submission, the Crown following its own procedure and not following what is set out in the Public Works Act. Paragraphs 219 to 220 discuss land which is still in Crown ownership and includes Part Pakenai number 2, Part Pakenai 2Y3 and Part Pakenai 2Y. Council wished to emphasise the findings of the Darrick report, which are also touched on in Trevor Shaw's surveys report. And Council agree with Mr Shaw's interpretation of the Act and submit that the land still in Crown ownership should be returned to the claimants who are descendants of Yehu Moitara. There's a lot of detail in the submissions in relation to the 1978 meeting where the Crown discussed the return of the land with the public. The important points Council wish to highlight there is that there's no conclusive evidence that the claimants tūpuna were present at that meeting and agreed to the resolutions that were passed. Ultimately, it's those resolutions that were passed which resulted in the further alienation of the land from the claimants and their tūpuna. So to conclude, the Y779 claim shows in detail how the Crown has failed to act in partnership with and in consultation with the claimants and their tūpuna in relation to the use and return of the Pakenai school site land. Over time, the Crown has failed to actively protect the claimants' tūpuna whenua by permitting the vesting of land in the Tokoro District Māori Land Board, permitting the alienation of land through public works legislation, and by permitting the Māori Land Court and Māori Trustee to alienate land without the express consent of the claimants' tūpuna. Respectfully, the claimants seek the findings, recommendations and relief set out at paragraph 325 on page 91. Kia ora.
Thank you.
Yes. Kia ora. Could I ask, thinking about the whole history of the land on which the school was built and returned, how would you characterise the official records over that period relating to the various transactions through the subsequent history of the land?
Official records in terms of court hearing records? Or
yes, or government records.
Yeah, so there is a lot of...
Education board records.
There is a lot of records held at Archives New Zealand, and that's where the claimants have done a lot of their research. And so if you get into all of those letters, there is a lot of toing and froing. But if you actually look at them in full, you'll see that there is a lack of consultation and a lack of understanding as to who owned the original piece of land, and it's those misunderstandings that have set in place the subsequent breaches and have dictated how the lands were dealt with once they were returned.
So are the transactions all transparent?
Not the first transaction. There's no court record. The first block didn't go through the Māori Land Court or the Native Land Court as a gifting of land. It got vested in the Tokoro District Māori Land Board first, and then from there went to the Education Board. So I'd say that in relation to the first block, it's not very clear, but in relation to Pakenai 2Y and Pakenai 2Y3, it is clear that it was Yehu Moitara who gifted the land.
Thank you. Well, thank you very much.
Dr. Anderson has no questions. Tēnā koe. Thank you very much for that. We move now to 284.
Yes, sir.
And 284A is an appendix.
That's right.
Ka pai.
Together with Ms Loader, we will present these joint closing submissions for Y1864, 2057 and 1857 regarding Mahi Tupapaku. Counsel Mr Stone sends his sincere apologies and means no disrespect that he's unable to be here today to present these submissions. Due to the nature of these submissions, the importance of the kaupapa, and that in full they're just over 6 pages long, and effectively cannot be summarised much further than that, Counsel Mr Stone has instructed we seek leave of your honour to present the submissions in full. Thank you, sir. So before we start, we just want to acknowledge and pay respect to the claimants' tupuna and whānau who have gone before us. We acknowledge the claimants' whānau who have been discussed specifically in the evidence and their presence with us here today. To open, there's a quote here from Daniel Ambler from a Hokianga hearing, and it reads, "When someone dies, they become more precious to us than at any other time in their lives. Our rangatiratanga, which is our ability to control our own destiny as Māori, has dribbled down to next to nothing." End of quote. What is the Tūpapaku claim all about, and what is the treaty breach? The Tūpapaku claim, perhaps more vividly than any other, illustrates fundamental differences in how Māori view death and all that it encapsulates, compared to that of non-Māori New Zealand. Given the subject matter, the claim is about taha wairua, spirituality, and how spirituality dictates how and why we do things. In that respect, the claim is inextricably linked with tikanga, the right way of doing things. This claim also concerns tapu or sacredness. Taha wairua, tikanga, and tapu come together to help shape our cultural practices in respect of mahi tūpapaku. These principles are core to our being as Māori and contribute significantly to who we are as a people. They are concepts imbued with the tapu of our ancestors by their strict adherence to their sanctity, compelled by years of practice, belief, and protocol. That these principles represent so much to Māori is not disputed. The problem is that they are simply not understood nor respected by those placed in the special position of handling our loved ones, and by those charged with creating the law that governs them. These concepts were not meant to be negotiable, or guidelines, or practice when one felt like it. They were meant to be respected and strictly adhered to. And that is what this claim is all about. Our tikanga, our rules, the way we were meant to do things in respect of our dead. The Crown has treated these rules and concepts as simply unimportant. Our tikanga, our rules, our belief systems, they can all be ignored. An undertaker can tell Māori to leave the room if they so wish, and Māori have to listen. To leave our dead alone goes against who we are as Māori. We simply don't do it. But we have no choice, and Māori are powerless to do anything about it. Our traditions, our beliefs, our way of doing things, they were meant to be guaranteed to us as Māori under the treaty. And to be powerless about something so tapu and fundamental to us as a people is intolerable and must not be permitted to continue. And that is what this claim is all about. The collective closing submissions filed for this claim were presented at Hokianga Hearing Week 20. And in particular, there was a brief evidence of Mike Pehi, Reverend Daniel Ambler, Professor Patu Hohepa, Pirihira Matarolo, and the joint brief of Pirihira Matarolo and Heriora Babirako. The law of jurisprudence. Why 1864 may have been the first claim to raise issues in respect of mahi tūpapaku. Nonetheless, Council submits tribunal findings in respect of partnership, good faith and active protection are all applicable to this claim because the concepts and the principles are the same. Māori customs and practices, or tikanga, were guaranteed under the treaty. It stands to reason then that if Māori customs and practices have been breached, compromised, ignored or severely undermined, then the tribunal must find that there has been a treaty breach. The evidence. In Council submission, the evidence illustrates that the law governing the handling of tūpapaku clearly breached and continues to breach tikanga. The evidence was plain and uncontested because it was incontestable. The evidence, although simple, was overwhelming. The evidence was also disturbing, not only because of the subject matter, but because instinctively we knew that it was wrong. It was wrong for Kashmir's brains. It was wrong for Kashmir's brains to be removed without the family knowing. It was wrong for Kashmir to be left alone at the undertaker's for 2 days. It was wrong for her mother and auntie to be denied access to her body. It was wrong that they took Dilly's organs without the family knowing, and we knew that it was wrong that they were returned a month later after they had buried her. What happened to Kashmir and Dilly were not isolated incidents. It happened to Reverend Daniel Ambler and his son Laurie too. Nearly word for word, the same thing happened with Kashmir and Dilly, happened to them as well. 3 different times he asked to be with his son while a post-mortem was performed. Each time he was declined. He pleaded, "Whatever you take out, put back. I don't want it sent back in the mail." 2 months later to the day, that is exactly what happened. The police showed up at his doorstep with a box. "Here is the tissue of Lawrence Ambler," is what they said. Again, we knew this was wrong. It was wrong because it was repugnant. We found it abhorrent, not just because it was non-culturally treaty compliant, but because it clashed with what we knew to be right as Māori. As Māori, we know that this is wrong, but does the Crown know that it is wrong? Perhaps they do not, because it's still happening. Further, the law has not changed. Section 25, subsection 3A of the Coroners Act 2006 says, "Members of the immediate family may view, touch, or remain with or near the body, but only if authorised to do so by the coroner." This means the law is subjective and subjugates the mana of the body away from Māori and gives it to the coroner. And in respect of an undertaker, the same subjectivity exists. If the undertaker does not want you in the room, you have to leave. The relevant sections of the Coroners Act applicable to this kaupapa are attached as Appendix A. Problems with the Act. It is Council's submission that the following problems and issues arise with the Act. Section 42 assumes that a coroner will perform their duties as quickly as possible. But what if a coroner is not available? Or a pathologist? What if one is not available? Especially if the coroner directs that a post-mortem be performed. Reverend Daniel Ambler had to move his son 3 times to find one. Mata and Bubby gave evidence that they had to wait too. This places considerable stress on an already stressed whānau. In most instances, delays occur between the police and the undertakers. The police do not know what they are meant to be doing. Mike Pehe, a claimant and funeral director, said that there have been many instances where, in terms of tikanga, the police have got it wrong. This is not necessarily the fault of the individuals. I think it's a case of them not being trained properly about the Māori tikanga. I believe the fault lies with the police training program not allowing sufficient hours to train tikanga to their recruits. It all starts at the top, as the saying goes. Section 43, subsection 1 says the body cannot be released any earlier than 24 hours, but does not say that there is a maximum time before the body must be released. The issue here is how long can they keep the body for before the people can get it back? While there is the possibility that the body can be released earlier if there is a senior sergeant who agrees to release the body, what if there isn't one available? It means the people have to wait. Section 49 says that the coroner has the power to authorise the retention of a body part or bodily sample under Section 48, subsection 2b. Section 48, subsection 2c is a toothless tiger in the sense that even if the people object, that isn't the end of it. The coroner still has the mana, and Section 48, 2b has precedence on 2c as authorised by Section 49. So even if the whānau object, the coroner has the final say. Remedies. What do Māori want from this claim? Stop excluding Māori. Start talking with Māori and start listening to them. Start understanding what's important to Māori. Incorporate Māori values, Māori belief systems and Māori worldviews. Include Māori at the decision-making level, at the level of the Chief Coroner, within the New Zealand Funeral Directors Association and within the New Zealand Police. Establish a Māori advisory group to advise the Coroner's Office, the New Zealand Funeral Directors Association and the New Zealand Police. Bring back Te Pau Te Reo. At present, the rules relating to Te Papaku have almost nothing to do with tikanga and are devoid of concepts fundamental to Te Ao Māori, and it needs to change. Māori having input will help to change that. The claimants seek then changes to the law. No longer should undertakers or coroners have the power to instruct our people to leave or to stand outside. We must have the right to keep our bodies in sight at all times. Respect our tikanga. The Crown needs to understand that it is very important to Māori. Acknowledge our customs, make provision for them, and let us practice them. What is done, and what happened to Kashmir, Dili and Laurie and so many others cannot be undone. But the Crown is obliged to make things right. It can still apologise. It can change the rules and the laws so that it doesn't happen to others. It cannot be permitted to continue, and the claimants welcome a finding that what happened to Kashmir, Dili and Laurie was wrong, that it was a breach of the treaty, and the Tribunal recommend that the laws be changed so that this never happens again. Over 22 weeks, the Tribunal heard from people who have lost their lands, many of whom are the mokopuna of Rangatira and Manawahine, who were owners of vast estates of land. Yet today, for many of those same people, the only land they own are the lands upon which their marae stand. And not only did they lose their lands, they lost their sovereignty too. They may not have ceded it, but they have lost it nonetheless. And many more cannot speak te reo than those who can. For many, all they have left is their tikanga, and that's why the Crown must not be permitted to take that away as well. Kia ora.
Tēnā koe. We have no questions. Thank you very much for providing those closing submissions for those claimants.
Thank you.
Tēnā koe. Ms. Rongo, you are presenting for Y974.
That's correct, sir, and it was given number 3.3.245.
Thank you.
Right, so these submissions are presented on behalf of Rosario Hotere and Jane Hotere, who have brought this claim on behalf of Ngā Hapu o Hokianga, Te Uri o Hau, the Mane Hotere Hapu, and Ngāti Kaha o Tau Maui Hapu, Y974. Now, the first statement of claim filed with the Tribunal in January 2002 focused on the public works takings in areas in the Hokianga, in Waimate Taimai ki Kaikohe and in the Whangarei and Takatamoana area. She focused on public works and the native land laws because her whānau were aware that there were massive amounts of land that were held by their whānau that were no longer held. Now, going through the process of this inquiry, we've had a lot of technical research that was completed, and it became clear to the claimants exactly how their land was actually lost. So an amended statement of claim was filed alongside these closing submissions, adding further causes of actions, which included how the claimants lost significant areas of their land. It included actions and pressures from the Native Land Court, local government, as well as the use of rating by local governments and the Māori trustee, as well as the native land laws. Now, additionally to that, they also included causes of action on urbanisation, economic development and socio-economic issues. I'll start with the cause of action concerning the Native Land Court. We adopt and fill the generic closing submissions filed by Morrison Kent and presented during the generic hearings. Now, it's Council's submission that the Crown established the Native Land Court for four main reasons, those being to convert customary ownership into individual title, to facilitate the alienation of Māori land, and that led to the undermining of customary authority, as well as the destruction of tribal structures. It's also Council's submission that the rapid alienation and the Crown purchasing that occurred subsequently to land passing through the Native Land Court would not have been possible without it. The transformation of tenure from originally hapu owned to being individualised made it easier for Māori owners to sell their land rather than retain it and use it. The Crown failed in this respect to provide also for the complex and sometimes overlapping customary interests that existed in land and resources which were held in accordance with tikanga. With no recognition of these customary interests and rights, much land passed through the Native Land Court, and that land was then placed, instead of in hapu title, it was put into individual names. And hapu interests usually range from exclusive rights of control through to occupation rights or just use rights, but the claimants weren't able to have some of their interests in the land recognised due to the lack of those titles being available to them. The only option was the individualisation of title. Now, the claimants don't say or don't deny other hapu from having interests in lands that they have interests in as well. Just like the claimants, it differed depending on their whakapapa and other factors. As well, the Native Land Court conferred absolute title on a defined area of land to a defined list of owners, far from the customary rights and interests that existed under tikanga. And today we now see hundreds of owners with varying degrees of interests on the lists of land, which sometimes prohibits the development or in some cases the protection of that land. And today we also see the claimants that are left with insufficient lands for themselves and their future needs. The Native Land Court also led to significant costs which the claimants had to bear, which included surveys, hearing costs, travel costs and fees, just to participate. Those costs were very burdensome and also led to the alienation of land. The court also allowed land to become landlocked, and I point particularly to Kohewhata 7B, 1A and B blocks, which were unable to be accessed, utilised, lived on at all because of the fact that they were landlocked. Moving swiftly through the closings, I then look at Māori land alienation 1865 to 1900. Now, Waikato, Williams and Davies filed generic closing submissions on this issue, and we adopt those in full as well. Particularly in regards to the tamana payments, which of course were the practice of making advance payments to owners without looking further into exactly who the owners were or what kind of interest they held, and without consultation with the other owners. One Crown land purchase agent who was very successful was Brissenden, and he used tamana payments quite frequently. He often made those payments to the wrong people, pushing on with surveys even when they were opposed by other owners, and the evidence was that he cut corners just to speed up the process. We pointed to 3 transactions in which he was responsible for in the Mitimiti area, in particular Wara Wara and Kutihainga and Ototope. The Crown had stripped away the collective control of the land through the Native Land Court, and whānau then were left without the ability to manage their lands themselves, their own way, and it imposed protective mechanisms that failed to do any protection at all. Brissenden failed to set reserves that he should have set aside for the claimant's future needs, and he ignored restrictions, and his determined and comprehensive purchasing program was designed to obtain as much land as possible in as short a time as possible. In the closings, we also look at the Crown purchase of Pārahirahi. There will be submissions presented in week 25 by the trustees of Pārahirahi C1 that cover this issue in detail. The claimants just wanted to highlight this as an example of the Crown's continued assault from all fronts, especially given its restrictions that it placed on the land that it ignored itself. The Crown breached Te Tiriti by failing to ensure that owners were left with sufficient lands for their future and their current needs, and it failed to guarantee that owners were left undisturbed to enjoy their land and resources as they wished. It failed to actively protect the owners' property rights and to act honourably and fairly as a treaty partner. Tuco Legal filed generic closing submissions on the 20th century alienation, retention, titling and administration of Māori land, and we adopt those submissions in full. And say, in particular, with regard to the Whakataha Z1C, that the ability of shares in Māori land to be mortgaged is a breach of Te Tiriti. Ms. Jane Hortere gave evidence in particular about one trustee that was able to mortgage her shares in the block. But any compulsion for Māori land to be sold is a breach, and the impact is felt by those that weren't part of it, that also have ancestral lands. When a willing shareholder signs documents enabling the alienation of land shares and defaults in the payment of the loan, the people affected most are those that have chosen to retain their lands. I say further that a situation like this wouldn't have occurred if land had remained under the authority of a communal customary ownership and management, as land had been prior to the passage through the Native Land Court. We also look at the Native Housing Act 1935. The purpose of that act was to grant loans to Māori for a wide range of housing activities, and in the evidence we find that portions of Te Raire 6, 7, 8 and 9 were sold by the Māori trustee to the Crown for purposes of the Māori Housing Act 1935. It appears that some whānau defaulted in their loan payments, and consequently their interest in the Māori land was sold by the Māori trustee. I then go to look at the Europeanisation of Māori land and adopt the submissions that are contained in the Y1465 closing submissions. In those closing submissions, I look at them at Europeanisation of Māori land in full. But with regards to the Y974 claim, 38 kohe whata sections and 15 tuhuna sections were declared European land under Part 1 of the Māori Affairs Amendment Act, without the owner's knowledge or consent. A few of the land blocks listed changed the status of their land back to Māori freehold land, but there were some that didn't, presumably because they didn't know what had happened with their land. Looking at public works, the main issue of the original statement of claim, we adopt in full the generic closings filed by Benyon Law. And we say in particular that we urge this tribunal to adopt the findings of the Tūranga inquiry as well as the CNI inquiry, and that if the Crown sought to compulsory take land for public works, then it follows that under that obligation as a te tiriti partner, that the taking is done as a last resort and in a manner which is consistent with the fundamental rights guaranteed to Māori under te tiriti. All options should have been exhausted before turning to Māori land, and even then, full alienation of the land should have been the last resort. Options such as leasing, easements and licenses should have been considered first. And given the huge contribution that the claimants had made towards the infrastructure in Te Paparaiho Te Raki, compensation for any taking should have been negotiated with them.
Do you have any general idea on what, when you talk about huge contribution, you're talking about in terms of land taken under public works?
Yes,
And
that's correct.
do you have any idea on what that sort of rounds out to?
I have listed quite extensively in these closing submissions, in support of the submissions that I make, examples of land that were taken for public works, for roading, defence purposes, schools, scientific and industrial reserves, railways, recreational reserves, and I also look at taking for shingle and taking for shale pits. So it wasn't just for land, it was also for the resources used to build roads and the railway. So overall, what I'm saying is that it was imperative that the Crown gain consent from the claimants before they went ahead and took any land and resources for any purpose. For the claimants, a significant part of this is also the lack of control that they had over their land and resources. They were pushed to the back while others, who weren't necessarily wiser than them, made decisions concerning their land. And we need to also bear in mind that this is land that was passed down to them through their whakapapa, from their tupuna. It wasn't a commodity, it was a taonga. Right, with regards to local government and rating, we adopt in full the submissions filed by Zoan Legal concerning the generic closing submissions. Now, the claimants had extensive land interests in the Kaikohe area, and through technical research, we discovered that the policies of the Kaikohe Borough Council, the Ministry of Works, the Public Affairs Department, Māori Land Corps, and the Māori Trustee all worked together towards alienating Māori land within that Kaikohe township and the surrounding area. What we found was that much land was sold for rates arrears, but what's interesting is that the Kaikohe Borough Council's own rates rolls were incorrect, and it actually also sought to receive rates for land that had been vested in the council itself over 5 years previously. That's how out of date they were. Although the borough still thought that Māori should be liable for the rates on these public roads. They also failed to send their rates demands to the correct person, instead sending them to Māori Affairs. They continued to class land sold to Pākehā as Māori rate defaulters, so the amount of Māori rates arrears were skewed because they weren't actually rates owed by Māori. They overinflated their Māori rates problem. And the council also complained to the Māori Affairs Acting Secretary Hun when he came to their area about Māori not paying their rates, but when it was looked into further, it's not clear how exactly Māori could pay their rates because they weren't receiving, they weren't aware that they owed rates, how much they owed. But of course the council blamed the difficulties on Māori for the complexities in their title, which Māori weren't even a part of creating. Besides charging orders being placed on land titles for rates arrears, the council also used other means. Owners were denied a connection to water supply, and they were told that a connection would only be considered after the rates were paid. And sewage reticulation was also withheld from another block. The claimants at this time felt frustration, hopelessness and isolation as a result of this local government action, and their decisions ran deep. We then look at the racism that existed in Kaikohe during the establishment of the township. Examples include Māori ownership of the new house sites was seen as hindering development possibilities because Pākehā did not want Māori neighbours. The borough restricted Māori access to their urupa in the middle of town, and the borough even tried to remove the remains from another urupa. The borough rejected street names that the claimants had put forth on land that they subdivided themselves. Now, we know that naming was an important part of claiming, and the borough assumed the right over the claimants. Kaikohe Borough was easily Northland local body most prepared to use rates charging orders and other enforcement measures. In my closings from page 42 to 66, I look at the charging orders that were placed on land in which the claimant have interests, and they are extensive. And I did that to highlight the extent to which the Kaikohe Borough Council worked towards driving the claimants from their township and off their ancestral lands. Sterling looks at the amount of land that was lost due to rates arrears, that was alienated, and on page 66 I list that in Kohewhata, Tuhuna and Taraire. Additionally, I found some more that I'd like to add to that list of land that was effectively sold as a result of rates arrears, and that was in Te Poia and Kohewhata. But what I found hard to determine was the amount of land, or sinking blocks, or sale blocks as they were known, that were sold to clear charging orders for rates arrears on other pieces of land that the claimants actually wanted to keep. But what is clear from the evidence is that the claimants were regarded as squatters and removed. Their land was no longer their own, in the very real sense that they could not just stay there, as the treaty guaranteed, and they had to fight hard to retain control of their land because policies and legislation gave councils the ability to argue that they weren't utilising it in the manner that they approved of. We support in full the generic closing submissions filed by Rainey Collins on the economic development and capability. And in our closing submissions, we list a few examples of how the claimants were left with an insufficient land base with which to be able to provide for themselves and their whānau into the future. And we talk a little bit about what the sufficient land base means. It's more than just the amount of land that's required for the claimants to live upon. It also included the amount of land needed for the future well-being, which included participation in the economy. So economic opportunities for the claimants were endless. When we look at the quality of land, they could have participated in farming, milling, mining, fishing industries, as well as the tourism industries. And if the claimants wished to participate in the local economy, then a sufficient quantity of lands and resources was required. And a sufficient quality of lands also was an important factor. And the opportunity for the claimants to acquire the skills, knowledge, technology, and capital to participate fully. And important issues for the claimants concern urban migration, and we adopt Rainey Collins' social economic issues generic closing submission in full, especially in regards to the dispersal from the tūranga waiwai. In the 1950s and 60s, the Crown encouraged Māori to move away from rural areas to existing urban areas, and they started to limit the resources provided to rural Māori communities. By doing this, the Crown failed to take the claimant's relationship with their tūranga waiwai into account, and this resulted in the claimants moving away from their homelands in search of better education for their children, better jobs, better health care. And as a result, the claimants say that they have suffered and continue to suffer from their disconnection from their tūranga waiwai, being dispossessed of the land that they weren't at home to protect, disconnection from their hapu and whānau, leading to the loss of te reo and a loss of the strong whānau connections that they could have had if they were at home. And the claimant says that we were part of that mass migration and we were struggling, and worse, there was no returning home. The claimants' whānau that were left at home as ahika also have suffered by having limited resources, including healthcare, education, employment, but also the human resources that they needed to run their marae and to look after their gardens and to be there when people returned home. Awhiaki Chambers filed generic submissions on environment, water and other non-land related resources, which we adopt in full. And same particularly with regard to the toheroa from Miti Miti Beach, that the claimants in their whānau were kaitiaki of the toheroa found there. And from 1924 right through to the 1950s, they met with ministers and Crown officials because they had concerns about the Europeans that took toheroa and sold them. By the end of 1948, the Crown had failed to acknowledge the committee that the claimants set up themselves, the whānau set up themselves, to protect the toheroa. The Europeans rejected the authority of the committee and took as many toheroa as they wanted. And in the 1950s, the toheroa Miti Miti Beach were all undersized, and taking of toheroa was finally declared to be illegal. During that section, we also look at the effects of public works takings on the environment. During the public works cause of action, we looked at the shingle that was taken from river, as well as the gravel from Moitangi River. And the claimant has given evidence that on what affected them most, and that the public works officials were able to access the land and take these resources without even talking to them. The extraction of shingle from the river was not sustainable, and it has led to the decrease in river flow. And the effects of that is the quality of the remaining water left over has diminished. The quantity the marae is able to utilise, and the survival of the kaimoana as well in the river is affected. The claimants have raised their concerns and have repeatedly been ignored or overruled by the Crown. And when pitted against other interests, Pākehā with commercial interests as well as council with their roading requirements, then the claimant's interests have just been forced to cede for the national interest. There was never any consent obtained or even consultation, there wasn't notification, and it falls short of the standard of active protection in partnership with the Crown, which the Crown must meet. In order to meet the standard, the Crown should have obtained the consent of the claimants. We then go to look at the prejudice and the relief and recommendations that are sought by the claimants. So those are the closing submissions for 1974.
Thank you. Anne, do you have any questions?
Kia ora, Ms. Rongo. I wonder if you could just explain again in relation to the kaikohe rates charging orders, how that actually, you referred to a sinking fund or sinking blocks. Could you just explain that, please?
Right, so the Kaikohe Borough Council, they placed many charging orders on land in their area with the aim to being able to utilise that land, specifically to move Māori off that land and to start developing it, either in the township or in housing developments. They did that through charging orders that they placed. The Māori Land Court, Native Land Court were able to put those on, and they stayed on the title, and unless the owners paid that, it was a risk that that land could have been sold for rate arrears. Sinking blocks was when other pieces of land that may not have been as, well, there may be priority land that some claimants didn't want sold, so they would use other lands that weren't quite as important, still important, but not quite as important, that they sold to retain that land. Those are sinking blocks, and what's not clear to me is if there was sinking blocks used in this, in Kaikohe area, because we know that there were some Sterling lists blocks that were sold due to rate arrears. I list some that in addition to his, that I think were sold due to rate arrears, or at least pressure from the local government. And I think there may have also been some other areas of land elsewhere that could have been sold, and that money used to pay off charging orders for other land. I just don't know.
And so when such land was sold, was it vested in the Māori trustee, or the court sold it, or how did that work?
Yeah, so some charging orders, if the rates weren't paid, then it was vested in the Māori trustee to sell, and then they would hold that money and then pay the local government, the Kaikohe Borough Council.
For the rates arrears. And are you aware of whānau who had to leave where they were living, had to leave their homes as a result?
I am aware of that evidence. I don't know the specifics right now, but I can follow up on that if you want. It's contained in technical evidence.
Thank you, that would be appreciated. Thank you very much.
Just waiting for her to finish her writing. At paragraph 42, you talk about a 380-acre block being taken for a school, which seems an extraordinarily large amount of land to be taken for a school. Can you tell us a bit more about that?
Yeah. That stood out for me as well, the 380 acres that was taken in 1948 for a technical school that wasn't built.
Right.
That's in the Pārahirahi block, and I found that after reading through Rosemary Damon and Dr. Donald Loveridge's technical evidence that was filed on the record of inquiry. These specifics I can find out for you, but I do know that in the next hearing week, the trustees will be presenting their closing submissions, so they may be able to answer your question, or I can look into that further to make sure that they do.
Well, let's give them a chance to to bring the submissions about that, and we'll double check that they actually do so. Thank you. Look, I don't want to go into family history or disputes within the family, but at paragraph 16, you quote Ms. Hoteri saying that she has problems about particular people that are named in the title. And I'm just wondering, is she saying that the court back in 1870 gave the blocks to the wrong people, or is this about individualisation as opposed to hapu ownership? So can you explain a little bit more about that quote?
Yes, the reason why I used that and the context that I wanted to include that in was the fact that this wouldn't have happened if land was still held in communal ownership. It was only due to the individualisation of title that led to land being held by people that weren't part of the whānau. But yes, some of this land has been returned to Māori freehold land, and it's not, according to the evidence here suggests that that the names of the current owners on those blocks were not original owners or do not whakapapa to that land. I have a feeling that I'll need to get back to you on that I'll need to check the evidence just to be sure that I'm not providing evidence from the bar.
All right, thank you very much. Thank you.
Thank you.
Thank you, Ms. Rongo. Thank you very much for your submissions.
Thank you.
Tēnā koe. Tēnā koutou. Okay. Oh. Kia ora koutou. Kia ora tātou. Mr. Hockley, just to confirm things for tomorrow then, the timetable, just got a couple of questions. We will start tomorrow morning with Tāmaki Legal in 3.3.260.
Yes, sir.
And then 256. And then 264.
Yes, sir.
That'll be the morning session. The next session we have 255, submission 255, 258, 269, 281 and 294.
That's correct, sir.
Now the next session we have 256 and then I've still got a blue for Y1525.
Yes, sir. We've sorted that situation out. It does have the number 3.3.306. Mr. Merito has clarified that for us.
What was that? 3.3.306.
3.3.306. And that will be the last of the Awhiaki Chambers closing submissions.
When was that filed? Yes.
So that was filed on the 12th of June. Now, in Your Honour's memorandum directions 2.6.261, you left the way clear for us to file on that date, sir.
Okay, ka pai. And then after that, we have Ms. Rongo with 244.
Yes, sir.
And then Morrison Kent 259.
Yes.
And then what do you have next?
We have the break then, sir.
Okay. I've got...
Unless you're waiving that.
I've got 254.
254 needs to be on the Friday, sir, because
Okay.
those clients can't make it then. So
where does it go on the Friday?
it'll go after the Rainey Collins submissions
Yes.
in the first session.
So after 259, then we have the break, and then we go 240, 303, 380, and 378.
278, but that's correct.
Oh, sorry,
sir.
278.
There, and I just wanted to let you know there is Mr. Sherrick wants to make a tono for some time.
Yes, sir. If it's possible, I didn't obviously get through all of my submissions the other day, and if it would be possible to crave your indulgence for somewhere between 20 minutes and half an hour to deal specifically with the development bank concept and principles of Maori enterprise, with the concept of remedy being towards provisions of nets rather than fish as a sort of a thematic concept, sir.
And when were we squeezing that in?
That perhaps at the last thing on the last day, if it was to be done at all, sir.
So not tomorrow?
Not tomorrow, Friday.
Okay.
If it could be, I'm flexible, sir. I could do it now.
Well, you'll be doing it alone. Now, for the Friday, we start with Ranfilly Chambers with 279.
Yes, sir.
And then Rainey Collins with 253 and 263.
Yes, sir. And there we
Then
have,
Morris and Kent 254.
That's right.
And what is the situation? I've got Tony Shepherd on here, but we have no document.
There was no submissions filed, as I understand, sir. So I believe that's vacated now.
Okay, so that's why I missed it. And then we go to Tūpono Law with 291. And then Tūpono Law has the rest of that, the whole of the next section as well.
That's correct, sir.
Okay. And looking at it, we could probably on the Friday, we'll obviously start at 9, but we could probably do 100 minutes there and do morning tea at 10:40, and then come back at 11 and go all the way through to 12:45.
Looks good to me, sir.
But we also have Mr. Sherrick wanting us to sit in a bit longer. Okay. We'll consider that, Mr. Sherrick. But as long as we've got tomorrow all arranged and we all know where we're going. Ka pai.
Sir, just, sorry, in the flurry of numbers, my friend Mr. Watkins isn't concerned. He's in the final session.
303.
Ka pai. Kia ora, sir.
I saw you run in. I thought you might have been a bit worried there, Mr. Watkins. Ka pai? Okay, thank you. Any other matters from Council? Stewart? Karakau? Oh, Hona?
Counted 10? You do a count.
Also, I'd just like to acknowledge Maureen Hickey and Nigel Fife for being in the house. And I know you and your team, and of course yourself, Your Honour, and your team.
Thank you.
I'd like to thank the ua, the makariri ki waho. It was all awake today and helped us to concentrate. Hoi anō, tuku e tēnei wā ki te tātou matua, taipui, tēnā koutou.
Tēnā koe, Hona.
Ko mai ngā tari whā te maunga, ko manga muka te marae, ngā puhi te whare hokianga, te moana ngā puhi nui tonu, te iwi e ngā reo, e ngā mana e ngā kāranga, ranga maha nau mai, haere mai. Tautoko.
Ai tēnei timi kona kia kouti te whānau, ko tai ki te wako motu, marika ngā ahutanga mai tēnei o ngā huihunga. He huinui tēnei mō rātou ngā whanunga katoa ko hono mai ki tēnei tāngo tātou. Ko tēnei e whakarongana ki hau mai te marae o te ranga Parawa. Kia ora, and here we've come to another end of another day with the week 24 of the Waitangi Tribunal Hearings. That's here with Total FM. And we're pleased to bring you a live broadcast from week 24. It's the closing submissions from the Waitangi Tribunal and Te Paparahi o Te Raki. And we've been into week 24. There's 26 weeks in total. And this has come to a time of listening to the closing submissions. This week we've heard from mainly the lawyers. And today we've heard from our whānau from Mangakahia. And this afternoon, the beginning of the closing submissions from the Hokianga. Nō reira ngā mihi kia koutunga whananga tēnei noho mai nā i o koutou kāinga putuno te ao. We're now live streaming, and hey, big kia ora to our technicians from here at Tautoko, our first live stream, making history. And of course, we're the only station who have broadcast live the 24 hearings of the Paparahi o Te Raki, and many of our whanaunga listing in many parts of the world, including Australia. Ngā rohe katoa te ao ka mihi nui kia koutou ngā whanaunga tini katoa. We're back with you at around 8:30 tomorrow morning, and we'll be continuing with the submissions from our whānau from the Hokianga, and Friday will end this part of the kaupapa at around 1:30 in the afternoon. Nō reira rā, ngā manakitangi kia koutou katoa, ka tuku ngā reo whakamonu ki atua ki iho ngā mano. Mga manakitangi kia tātou, piki te kaha te ora, me te rangi maari kia tātou katoa e te whānau. Nō reira, mauri tū, mauri ora.